Mr. Speaker, sir, I beg to move this resolution under the relevant rules of procedure and conduct of business. Mr. Speaker, sir, whereas the three autonomous district councils, namely Khasi Hills Autonomous District Council, Jaintia Hills Autonomous District Council, and Garo Hills Autonomous District Councils, are established under the mandate of the 6th Schedule of the Constitution of India and are vested with power and responsibilities for effective administration of the 6 scheduled areas of the state of Meghalaya. And whereas the ADCs require to fulfill the objective as enshrined in the 6th schedule of the Constitution of India in the best interest of the scheduled tribes of the state of Meghalaya. And whereas the objective of the mandate of the Constitution of India requires ADCs to fulfill responsibility towards preserving and protecting the identity of our tribal people in respect of our rich tribal heritage, tribal land and resources within the 6th schedule area, including the administration of justice as per the customary laws and traditions for overall welfare and interests of the tribals of the state. And whereas the ADCs are till date not adequately supported to ensure financial stability for fulfilling the constitutional responsibility, thereby failing the objective of the 6th schedule of the Constitution of India, and whereas there is a genuine need for ensuring predictable, viable source of revenue for the ADCs in the state for their financial stability, and whereas the state legislature has enacted the Meghalaya State Finance Commission Act 2012, which is self-explanatory, and whereas sub-clause BB and sub-clause C of clause 3 of the Article 280 of the Constitution of India provides measures needed to augment the consolidated fund of a state to supplement the resources of, number one, panchayats of the state, and number two, the municipalities in the state respectively, on the basis of the recommendation of the finance commissions of the state. Now, therefore, this House to resolve to urge upon the Government of India to amend the Article 280 of the Constitution of India and add additional subclause under clause 3 of the Article 280 of the Constitution of India to empower and enable the Union Finance Commission to recommend measures needed to augment the consolidated fund of the state to supplement the resources of the ADCs in the state on the basis of the recommendation made by the Finance Commission of the state.
Motion moved. Now you may initiate the discussion, please.
Mr. Speaker, sir, this issue is before all of us, and we are all aware of the challenges being faced by the ADCs in respect of planning and implementing various programs for the welfare of our communities which belong to the scheduled tribe as per the provision of the Constitution of India, and not having the predictability of the kind of fund that is required to plan in the matter of implementing various programs for the welfare of the tribals within the given 6 scheduled areas, within the respective areas of the respective ADCs, and also to improve the level of governance, administration. This is pertinent and is confronting the challenge, the state and the ADCs. Now, in order to ensure that days ahead we are able to navigate through these challenges, in view of the provisions of the Constitution which is enshrined in it, specifically for the welfare of the scheduled tribes and for the purpose of supplementing the effort of the ADCs in improving the level of governance. Now, when we talk about this, whether there is a provision in the Constitution, because everything that we do in the matter of any proposal for spending of fund from the public exchequer, it is all governed by the mandate of the Constitution. We are all aware of this. We are all lawmakers. Now, even the finance commissions, the union finance commissions, have very elaborately reflected these concerns of the states, which were based on the engagement with respective states where we have the ADCs and 62 areas. Whether we refer to the recommendation of the observation and recommendation of the 10 Finance Commission, the 11 Finance Commission, 12 Finance Commission, 13 Finance Commission, 14 Finance Commission, 15 Finance Commission, and now while we are awaiting the recommendation, observation and recommendation of the latest Union Finance Commission. However, over the years, somehow or other, this very crucial responsibility, which is vested upon the state of Meghalaya and other states who have ADCs within the domain of the jurisdiction of the state, which almost covers almost 90+% of the whole area of the state, excepting the municipality area in Shillong, as it was notified in the act itself at the time of creation of the reorganization of the state. Now, I would like to refer to this very provision of the Constitution, which refers to the Article 275. Sir, this is which is relevant to us. The clause 1 of Article 275. Otherwise, we usually refer to it as Article 275(1) of the Constitution of India, which mandates the Parliament. I would like to refer to the content of this article. Such sums as Parliament may by law provide shall be charged on the Consolidated Fund of India in each year as grant in aid of the revenues of such states as Parliament may determine to be in need of assistance, and different sums may be fixed for different states. Provided that there shall be paid out of the Consolidated Fund of India as grants in aid of the revenues of a state, such capital and recurring sums as may be necessary to enable the state to meet the cost of such schemes of development as may be undertaken by the state with the approval of the Government of India for the purpose of promoting the welfare of the scheduled tribes in the state, or raising the level of administration of the scheduled areas therein to that of the administration of the rest of the areas of that state. Now, the interpretation is also reflected by many of the observations and recommendations of the Finance Commission. Different Finance Commission. There are too many. And every Finance Commission has referred to it. But what is happening is that under the Article 280, since the Article 280, the relevant clause which I have referred to, the clause 3 of the Article 280, only provides for accepting such recommendations of the state finance commissions which are constituted for Panchayati Raj. And also, the subsequent provision is to accept the recommendations of the State Finance Commission by the Union Finance Commission to recommend to the Union Government on the municipalities. There is no space for the Finance Commission, which should be vested with the responsibility of recommending such need of grants for the welfare of the taking up the developmental programs by the ADCs in respect of Meghalaya, which is the district councils. And this being absent, the terms of reference which are given by Union Government to the Finance Commission always is, by default, do not cover this particular concern, though there is a provision. Because, see, look at this Article 275(1). It is not a grant which should be voted by Parliament. It is a grant which is charged. No vote, no debate. So, this is the constitutional provision which has to be therefore leveraged upon by the state. And leveraging upon the state, we, again, this reference also is there in the recommendation. I would like to read this observation of the 13th Finance Commission. While the general power of sanctioning grants for rendering financial assistance is left to Parliament by Clause 1 of Article 275 of the Constitution, specific grants are enabled through the two provisions to the clause. First, proviso concerns payment from the Consolidated Fund of India without vote in Parliament of sums necessary for schemes of development, for the welfare of scheduled tribes, and for raising the level of administration of scheduled areas as may have been undertaken by the state with the approval of the Government of India. Now, therefore, this engagement with Government of India is very crucial. We tried in 2014, 15, 16, engagement with the Ministry of Panchayati Raj, because the Finance Commission, the Article 280, Clause 3, refers to only these two, Finance Commission for the purpose of Panchayati Raj and for the purpose of municipality. So therefore, this particular area of somehow not covering with this recommendation of the Finance Commission due to non-inclusion of the ADCs under the terms of reference for the Finance Commission. We took up this matter, and there was an aggressive, repeated engagement with the concerned ministry, particularly Ministry of Panchayati Raj, then Ministry of Tribal Affairs, and the Ministry of Finance and Ministry of Home Affairs. And we were able to, at least to make a beginning, make them agree that yes, we have skipped these areas of funding which is required for the ADCs. So they started giving us, at least, though this particular Finance Commission is not yet constituted for this purpose, and therefore no terms of reference can be given to the Union Finance Commission in the absence of this provision in Article 280. Therefore, we will start with the grant, one-time assistance first. That is where we got that fund for KHADC in 2015 and 16, and for Garu's Autonomous District Council, which was only for Garu's Autonomous District Council was 100.71 crore. Then JHADC, all the three ADCs were given, different amounts. Now, we are required to follow up. Follow up in view of these issues which have been discussed at different times, at different levels, including when we put our hands as government, along with Government of India and the then proscribed pre-disbanding organizations of ANBC. Here, in Para 77, it was incorporated, and this was part of the discussion which was held in this August House. Before we send it to Government of India, this issue was discussed as to how the tax settlement should be agreed upon and how it should apply to all the ADCs, not confined to only GHADC. And this was agreed upon unanimously by all the political parties at that point of time. So we should always connect with the circumstances in the bygone years and how this discussion was arrived at, how Government of India has become signatory. That means they are legally, constitutionally responsible to give effect to these intents. Now here in Para 7.7, it is said, an independent body like the State Finance Commission will be constituted to recommend establishing a proper basis for fund allocation and sharing of tax proceeds between the state government and the autonomous council administration. The Government of India and the Government of Meghalaya will initiate steps for necessary modification in the constitutional and other relevant legislative, procedural, regulatory regime. Modification in the constitution means amendment wherever needed. That is the reason of my intent of bringing this resolution. Because we have tried number of times, we have engaged with number of successive Union Finance Commissions, but we have seen the end result. Therefore, let us take recourse to this particular provision of the law, of the Constitution, and see that these funds are transferred, provided to the state based on this need. The need for enabling the ADCs to take up all the various developmental and welfare programs for our Jaipur, and to augment the level of administration of the respective ADCs. Augment the level of administration means provide the necessary support, the revenue expenditure which will be required for the payment of salaries. Therefore, once this particular space available in Constitution is invoked by us and we try to prevail upon this provision as a weapon to convince Government of India, I am sure we will be able to overcome this challenge. That's why I think we should collectively come to see that we explore this provision which is available and which has been in their observation appropriately articulated by number of the Finance Commission earlier. Now, here to create this enabling environment for us, we have referred to Article 270. It shall be the duty of the Commission to make recommendations to the President as to the distribution, that is the clause 3 of the Article 280, the distribution between the Union and the State of the net proceeds of taxes which are to be or may be divided between them under this chapter, and the allocation between the State of the respective shares of such proceeds. The principle which should govern the grants in aid of the revenues of the State out of the Consolidated Fund of India. To the measures needed to augment the Consolidated Fund of the State to supplement the resources of the municipalities in the State on the basis of recommendation made by the Finance Commission of the State. And the measures needed to augment the Consolidated Fund of the State to supplement the resources of the panchayats in the State on the basis of the recommendations made by the Finance Commission of the State. Here, there is a need to have this very provision wherein there shall be an added subclause to the clause 3, wherein we shall propose that because these are the constitutional mandate which empowers the Union government to prepare the terms of reference to the Union Finance Commission. In absence of this, the Union Finance Commission's terms of reference for the Finance Commission to look at all this transfer of resources for different purposes will be governed only by this. Only for panchayats and only for municipalities. Therefore, since we have the provision of Article 275(1), therefore, leveraging upon that only, we are saying that there is a separate mandate of the Constitution which should be decided upon by the government, and read Article 275(1), sum which will be proposed through the Parliament to provide and which will be charged on the Consolidated Fund of India in each year as grant in aid, which should be for the purpose of augmenting the level of administration besides enabling the resources to be passed on to the ADCs for the welfare programs of the tribal people. Now, here a word of caution, which I believe must be a rider inhibiting the state government. I also have gone through this during that time when I had the privilege of deciding on whether we should have this State Finance Commission or not. I looked at all the possibilities. Now, based on that understanding that this can be leveraged upon and can be based on these provided in the provision of the Constitution, we embarked upon that legislative exercise to have the State Finance Commission Act 2012. We already have that. Now, how this can be leveraged upon for the Union Finance Commission to take as a terms of reference to include this part will be determined by addition of the provision within the existing framework of the Constitution in as far as Article 280 is concerned. Or unless the Government of India decides to include in this particular article only in Article 275, that these grants will be determined by State Finance Commission constituted exclusively for the states, where the areas which are excluded under the relevant part, which is governed by the 73rd and 74th Amendment, are included. Here, therefore, I would like to again refer to this particular point that we included in the terms of reference. While doing so, we have looked at the possibilities and also whether it will ultimately land up in putting the whole burden of responsibility of transferring these resources only to the state. We examined that, but then it is not so. Because based on this requirement only, the State Finance Commission will also recommend to the Union Finance Commission, and Union Finance Commission, because the terms of reference will be then available for the Union Finance Commission, then they are mandated by the Constitution. So that is the thing. Here it says that the tax proceeds between the state government and autonomous council administration. These tax proceeds are not confined to the tax proceeds of the state's own realized revenue only. It refers to the fund which is available under the provision of Article 275(1), because Article 275(1) provides for Parliament to, by law, provide these funds both for the welfare and for developmental programs of the scheduled tribes area in the 6 scheduled areas, and also to improve or raise the level of administration of the 6 scheduled areas therein. So, Mr. Speaker, sir, this challenge will continue to confront us, this shortage of financial support, unless we prevail upon Government of India. We have tried earlier also. I remember during our time, it was we were always perturbed when the employees of the district councils come, when the members of the respective ADCs come, particularly Garhwal's Autonomous District Council and Jaintia Hills Autonomous District Council. Somehow or other, Khasi Hills Autonomous District Council have not faced this problem of not being able to pay even the salaries to the employees. But these other two ADCs. Now, there is sometimes a tendency to play, to the gallery and engage in gambling. I think we should resist from that. Because I am perturbed when sometimes we hear how the narratives are circulated when we try to pass on the bucks to others. It doesn't help us. It doesn't help all of us who belong to one particular class, the political class. We must remember that political class, people who belong to political class, are always at the receiving end, irrespective of where we belong to. Therefore, it is only, somehow opening up additional avenues for people to look at the people belonging to political class with that kind of contempt. It doesn't help anyone, because we have divine responsibility of carrying forward the state, divine responsibility of addressing concerns and issues that challenge and confront our people on a daily basis, that challenge and confront the policymakers and legislators on a regular basis. Every government has faced this problem. Yes, there was instances where district council has not been able to pay the salary of the teachers. But then at that point of time, maybe we did not see how we can prevail upon government of India to say that, look, ADCs are vested with more important role. Why are you not giving us money? I think it is time that we should all put our heads together and be collectively assertive to prevail upon government of India. I'm sure they will agree. Because I remember, if you go through the minutes of those few meetings which were held between the Panchayati Raj Ministry of Home Affairs, Ministry of Tribal Affairs, Ministry of Finance, and a number of other ministries who were involved in the committee for discussion. The minutes are there. The minutes will enable us to how to again format our requests to the government of India. I have only prepared this resolution so that the government will be in a position to work out the modalities of how we communicate collectively with the utmost sense of responsibility and how we become collectively assertive to prevail upon government of India. Every government has tried. I remember during our time, sometimes 9 months, 8 months, 10 months, we feel perturbed. We managed to release funds. There are a number of factors also. There are a number of factors which afflict the whole administration of district council. These are required to also be corrected. These are all appropriately reflected in the observations of respective finance commission. And they must be all attended to. And at the same time, the issue of this release of the state share, the share of the district councils from whatever revenues we realize, particularly from the major and minor forests, including whatever taxes are collected by the government of state government, whether it is in the area of transport, etc. I think we were given the hope that the government will release, in as far as GHADC is concerned, whatever share of royalty is balanced. I remember Honorable Deputy CM giving this particular statement, carried by media, that whatever royalty share is there, whether small or big, we don't know, will be released immediately. In view of the extreme hardship, and I think they have 43 months is not a matter of joke. Some efforts were also made to attribute these causes because of illegal appointments. Whether illegal or legal, by the ADCs. The state government has never interfered. I have not seen. During my time, in the course of my being in the government as minister or as deputy chief minister or as chief minister, in respect of ADCs, we have never interfered in the matter of appointment. But I am very perturbed and pained that sometimes these blames are passed on to Dr. Mukul Sharma, that during his time, illegal appointments were made. These are defamatory. When the whole population of the Garhwals region are somehow driven by emotion, this kind of blame has serious ramification on my safety, security, and personal repute. I would like to urge upon everyone to desist from this. It doesn't help anybody. It doesn't help the government nor the state. It will only be an unhealthy precedent for future. Politicians of the next generation will think that that is the appropriate way of dealing with issues, passing on the buck to the predecessors. It's not correct, because no one is going to be here as members in the government in perpetuity. There will be a day when somebody else will occupy will be vested with the responsibility of governance. So it will only create that kind of enabling environment for our future generation to pass on the buck to us. Therefore, it is being made abundantly clear that during my time, in 2015-16, the chief executive member of GHADC was Denang T. Sama. And that is the year 2015-16 when there was a somehow small incremental increase of employees in GHADC. It continued with the same thing. Then resultant retirement brought it down a little bit. Then it came up again last 2 years. So these figures can be looked at. I request the Honorable Deputy Chief Minister in charge of District Council Affairs to see that one, so that he himself also can somehow clarify that no, it is none of the Chief Ministers, neither the preceding Chief Minister, previous Chief Minister, nor the present Chief Minister is responsible for this. None of us. But the fact is that there is an intrinsic, inherent problem faced because of not being able to invoke the provision of the Constitution, having known that there is an enormous responsibility in the matters of governance, which is so clearly indicated in the provision of the 6th Schedule of the Constitution of India in respect to the ADCs in Meghalaya. I think it is only incumbent upon the state government and the state and the ADCs to come together and be assertive and take up with Government of India to see that what is due for our people, for the purpose of enabling these ADCs to shoulder the responsibility of not only implementing the programs and developmental initiatives, but also to increase the level of governance so that with dignity and honor, the members of District Council can shoulder upon themselves the responsibility of governing the 6th Schedule area in sync with the mandate of the provision of the Constitution of India. So with these few words, Mr. Speaker, sir, I have urged upon this House to come together, to collectively decide. I have only met the initiative. It's up to the government how you want to format this resolution. It is not necessarily that in my own wisdom, whatever text I have scripted and formatted is the best. There can be the government's own version of the resolution which should be adopted if the government decides not to adopt, as usual, because that is how we practice. But there was a time when I accepted and agreed to resolve a resolution when the honorable member from West Shillong brought a resolution in regard to inclusion of languages, our Khasi language, for consideration for inclusion in 8th Schedule. We agreed. We said, let's take a resolution. So there are precedents. When it is something which is pertinent and are going to remain as unresolved problems, we need to come out of this mess. And that is because we have not invoked this constitutional provision to be assertive with Government of India, and we land up in the same problem again and again. With these few words, I urge upon the government of the day and all the members of this August House to agree to resolve a resolution, to agree to resolve this and adopt this resolution in order to enable the state government to carry it forward and take it up with Government of India in order to ensure that the objectives of the provisions of the 6th Schedule of the Constitution is fulfilled in letter and spirit in the best interest of our tribal people. Thank you, Mr. Speaker, sir.
Yes, Srimati Miani Dishra, please.
Mr. Speaker, sir, I also rise to support the resolution brought by Honorable Leader of Opposition. The resolution which says, whereas the 3 ADCs, Autonomous District Councils, namely number 1, KHATC, number 2 GHADC, and number 3 GHATC are established under the mandate of the 6th schedule of the Constitution of India and are vested with power and responsibilities for the effective administration of the 6th schedule areas of the state of Meghalaya. And whereas the ADCs required to fulfill the objective as enshrined in of the 6th schedule of the Constitution of India in the best interests of the scheduled tribes of the state of Meghalaya. And whereas the objective of the mandate of the Constitution of India requires ADCs to fulfill responsibility of preserving and protecting the identity of our tribal people in respect of our rich tribal culture and heritage, traditions and way of life, and the constitutional responsibility of protecting, administer tribal land and resources within the 6 scheduled areas, including the administration of justice as per customary laws and traditions for overall welfare and interests of the tribals of the state. And whereas the ADCs are till date not adequately supported to ensure financial stability for fulfilling the constitutional responsibility, thereby failing the objective of the 6th schedule of the Constitution of India. And whereas there is a genuine need for ensuring predictable, buoyant source of revenue for the ADCs in the state for their financial stability, and whereas the state legislature has enacted the Meghalaya State Finance Commission Act 2012, which is self-explanatory. And whereas subclause BB and subclause C of clause 3 of Article 280 of the Constitution of India provides measures needed to augment the consolidated fund of the state to supplement the resources of the panchayats of the state and the municipalities in the state respectively on the basis of the recommendation of the Finance Commission of the state. Now therefore, this House do resolve to urge upon the GOI, Government of India, to amend the Article 280 of the Constitution of India and add additional subclause under clause 3 of Article 280 of the Constitution of India to empower and enable the Union Finance Commission to recommend measures needed to augment the consolidated fund of the state to supplement the resources of the ADCs in the state on the basis of the recommendation made by the Finance Commission of the state. Sir, this resolution, I think, is beautifully articulated. This is the requirement of the day. Sir, we have seen the current state of our ADCs. We have seen that the district councils of our state, the 3 district councils of our states, day by day is weakening. And time and again we've been saying that we need to strengthen our ADCs. Our district councils need to be strengthened in order to take care of our tribal identities and our tribal land. And I think it is the duty of every person in the state and us as representatives of our people and members of this August House to have the burden of responsibility to make sure that the ADCs are taken care of, are strengthened urgently. Now, the Honorable Leader of Opposition has already referred to all the relevant articles in the Constitution, which is very, very important and technical, and therefore it needs to be amended. Now, we know that there are only few states which have the ADCs, and in other parts of the country, in other states, we have the Panchayati Raj, and in other areas, we have the municipalities. That is the reason why only these two, the panchayats and the municipalities, are expressly mentioned. Therefore, there is an immediate need to pursue this matter and engage with the Government of India, so that there is a point of reference for the Union Finance Commission to enable them to fund and supplement the required financial resources of the ADCs. Sir, if we don't address this problem now, it will accumulate and further degrade the state of our ADCs. Therefore, I think the state government should take up this resolution and pass it in this August House. Therefore, sir, I also request the state government to provide and release the required fund for the salary of the employees of the GHADC and JHADC, which should be reimbursed from Government of India under provision of Article 275(1) of the Constitution of India. Therefore, sir, with these few submissions and these few points, I would like to give my support to the resolution and resume my seat. Thank you.
Now I will call the Minister in charge to reply, please.
Mr. Speaker, sir, at the outset, I am so thankful to the Honorable Leader of the Opposition, Dr. Mukul Sangma, an MLA of Songsak constituency, for moving and bringing in the resolution to urge the Government of India to amend Article 280, which I personally feel it is the most befitting topic that we need to discuss in this August House for the detailed clarity. So I'm so thankful also to the Honorable MLA from Ampati, Madam Miami Dishira, who supported the resolution. And sir, I will, because of the time's constraint, I will not read out the entire text of the resolution. Maybe I will just take only the last para, the operative part of it. Now, therefore, this House do resolve to urge upon the Government of India to amend the Article 280 of the Constitution of India and additional subclause under Clause 3 of Article 280 of the Constitution of India, and to empower and enable the Union Finance Commission to recommend measures needed to augment the consolidated fund of the state to supplement the resources of the ADCs in the state on the basis of the recommendation made by the Finance Commission of the state. To my understanding, I think the resolution has three parts, which needs to be elaborated upon. Firstly, I think to urge the Government of India to amend the Article 280. The second intention is to add the additional subclause 3 in the Article 280 that will empower the Union Finance Commission to recommend resources directly to the Autonomous District Council. And thirdly, the Union Finance Commission will ultimately, after the amendment, rely upon the State Finance Commission as the basis of the recommendation. I think these are the three aspects which is very important. As I've already said, sir, I'm so thankful to the Honorable Leader of Opposition. With a great concern, he brought this resolution today for clarification and for deliberation too. Sir, I would like to highlight the following key points for the benefit of the members of this August House. Number one, before I go into these issues, it is important to understand the brief history of the 6th schedule and the 73rd and 74th constitutional amendment. And secondly, the position in the Constitution with regards to the establishment of the State Finance Commission, especially the difference in areas covered by Panchayati Raj institutions and the 6th schedule's area. Sir, the autonomous district councils were constituted under the 6th schedule to the Constitution when the Constitution of India came into force way back in 1950. And the objective was for effective administration over scheduled areas by creation of an institution called the Autonomous District Councils, keeping in mind the customary laws and traditions of the tribal people who for centuries inhabited these lands. The objective behind constituting district council was to also preserve the language, culture, and heritage, customary laws, and land of scheduled tribes living in northeast India, including our state of Meghalaya. Sir, the 73rd and 74th constitutional amendments were approved by Parliament in 1992, which introduced Part 9 and Part 9A for Panchayati Raj institutions and municipalities. Whereas Meghalaya was specifically excluded under Article 243M and 243ZC, maintaining the 6 schedules distinct framework. Article 243I states that the governor of the state shall constitute a State Finance Commission within 1 year of the 73rd Amendment Act, and every 5 years, thereafter, to review Panchayat's financial position. The Commission's recommendation will cover distribution and allocation of taxes, duties, tolls, and fees, assignment of taxes to Panchayati Raj, grants in aid, and measures to improve Panchayat financial position, which the governor will lay before the state legislature along with an explanatory memorandum on the action taken. However, sir, Article 243M 2 subclause A specifically exempts the states of Nagaland, Meghalaya, and Mizoram from the application of Part 9 in bracket Panchayats of the Constitution, and consequently the constitutional mandate to constitute state finance commissions under Article 243I does not apply to Meghalaya. Number two, sir, the 12th Finance Commission clearly stated in the recommendation, 12th Finance Commission, yes, sir.
It is now 2 p.m. and in exercise of Rule 11 of the Rules of Procedure and Conduct of Business, I will extend the House till this resolution is disposed of today. Honorable Deputy Chief Minister, you may continue, please.
Thank you, sir. Thank you, sir. The 12th Finance Commission, I'll repeat again, the 12th Finance Commission clearly stated that the states of Meghalaya, Mizoram and Nagaland have been specifically excluded from the operation of the 73rd Constitutional Amendment, but the legislatures of these states have been given the power to extend this amendment to their state by law, except in respect of the 6 scheduled areas. They did so on the ground that the Ministry of Home was considering a proposal for amendment in 6 schedule to make autonomous district councils more effective. Again, sir, the recommendation of the 3rd Finance Commission endorsed the recommendation of the Expert Committee on Planning for the 6 scheduled areas set up by the Ministry of Panchayat Ministry relating to setting up of bodies similar to State Finance Commission in states which are not covered by Part 9 of the Constitution and are thus not required to set up SFCs. As recommended by them, the terms of reference of these state finance commissions like bodies may be patterned on the provision of Article 243I of the Constitution of India. Thirdly, sir, the 15th Finance Commission, in their last recommendation, recommended that all states which have no constituted State Finance Commission must constitute State Finance Commissions, act upon their recommendations, and lay the explanatory memorandum as to the action taken thereon before the state legislature on or before March 2024. After March 2024, no grant should be released to a state that has not complied with the constitutional provisions in respect of the State Finance Commissions and these conditions. The Ministry of Panchayati Raj will certify the compliance of all constitutional provisions by a state in this respect before the release of their share of grants for 2024-25 and 2025-26. However, sir, the state government has replied to the 15th Finance Commission The state clarified that the 15th Finance Commission's recommendation regarding the constitution of State Finance Commission, as referenced in their recommendation in para 7.57 and 7.58 of the Commission's report and para 5A3 of the operational guidelines apply only to states covered under Part 9 of the Constitution. Meghalaya is expressly exempted from the mandatory constitution of State Finance Commission by virtue of Article 243M as referred earlier, which excludes certain states from the ambit of Article 243I. Consequently, there is no constitutional requirement for Meghalaya to constitute State Finance Commission under Article 243I, and the reference recommendation do not extend to the state. So, in view of the above reference, sir, the release of the Finance Commission recommendation is still in flow to the state government, and there is no stoppage till today. Sir, went next para, the Meghalaya State Finance Commission Act 2012, as rightly mentioned by the Honorable LO, Dr. Mukul Sangma, that time when he was also the Chief Minister, we have passed the Meghalaya State Finance Commission Act 2012, taking into consideration that issues where we thought that by constituting, by having our own act in the state, at least we will be able to be accessible to the Union Finance Commission. But as of today, sir, till today, as I've already read out, till today, the Union Finance Commission still following the consideration of their recommendation from 5 years to another 5 years on the basis of the Article 243M and 243I. Mr. Speaker, sir, the Constitution 125th Amendment Bill 2019, it is coming step by step, and ultimately the government of India, because they have the intention to amend the 6th schedule, and in the name of 125th Amendment Bill 2019 was introduced in Rajya Sabha. It is specifically in the year 2019. In the year 2019, it was introduced, I think to be specific, the bill was introduced in Rajya Sabha on February 6, 2019, and it is specifically with the intention to the empowerment, the autonomous district councils, and also to fulfill the mandate of the tax settlement agreement. The government of India introduced the bill, which is till today lying with the Parliament. Sir, because the proposal, the resolution is to amend the Article 280. Let me come to this portion, which is very, very important, very, I should say, the bone contention of the proposed amendment by the government of India. The bill specifically proposes to amend Article 280 in bracket 3 by inserting a new subclause CA. Let me read the amendment. The measures needed to augment the consolidated fund of state to supplement the resources of the district councils. The word district council has been clearly included here, including municipal council, village council in the tribal areas within the states referred to in clause 2 of Article 244 on the basis of the recommendations made by the finance commissions of the said states. So this this clause, which is right now the property of the parliament, is exactly goes in line with the resolution, that text brought in by our Honorable LO. So it is already, sir. So from the government side, the state government has been following up time and again with the government of India on the passage of this 125th Constitutional Amendment Bill. The Honorable Chief Minister, a number of occasions, met the Honorable Home Minister as well as the Honorable Prime Minister of India and put more pressure for the early passage of this amendment bill. And once this bill is passed, I think all the issues discussed today, especially highlighted by the Honorable LO, will be taken care of. So, sir, I think with this clarification I made, before I resume my seat, once again I would request the Honorable Leader of Opposition, with my clarification, to kindly withdraw their resolution.
Can I know the mind of the Honorable LO, the mover of this resolution, whether he will withdraw his resolution or not?
Thank you, Mr. Speaker, sir. Before I express my mind to withdraw, I would like to, at the very outset, thank the Honorable Deputy CM very, very profusely for his power of comprehension of this problem, which is a reality and which we need to overcome. Now, we have to weaponize the available commitments of Government of India to achieve this at the earliest. Honorable Deputy CM is aware of one letter which was sent to State Government of Meghalaya, informing that the Government of India is already contemplating to give effect, to take up the amendment of the Constitution of India in respect to the 6th schedule of the Constitution of India, in sync with to give effect to the objectives of the tax settlement agreement between the three signatories: Union Government, the State Government, and the then pre-disbanded ANDC. Now signed on 24th of September 2014 at New Delhi in presence of Sri Rajnath Singh, Honorable Union Home Minister, Sri Kiran Rijiju, Honorable Minister of State Home, Dr. Mukul M. Sangma, Honorable Chief Minister of Meghalaya, and Mrs. Roshan Wardry, Honorable Home Minister of Meghalaya. This is a collective intent which must be revered in as far as this tax settlement is concerned. And precisely to give effect to this intent, as has been formatted in the tax settlement agreement after exhaustive due diligence and discussion, now they have embarked upon the measure to amend the relevant provision of the 6th schedule of the Constitution of India. But the problem is, as we are all aware, that this amendment was tabled in the Parliament 6 years before. There's undue delay. Our people are suffering. Our people have been promised. This August House have witnessed this promise, and we have collectively expected. And Government of India also, because of our persistence in 2015-16, they wrote that letter. So I think we have to see that reasons for the delay. We can never take Parliament for granted. We never know how the Parliament will decide. If all the things are clubbed together, because in this proposed 125th amendment, all other provisions in relation to the need to give effect to the amendment of the 6th Schedule of the Constitution of India also cover other ADCs. Therefore, the scope of debate and discussion has become too big, and therefore the delay. That is what I presume. I can take, as I have said, take the wisdom of the Parliament for granted. But then I think we have to take up this issue specifically in respect of the ADCs of Meghalaya. That is my submission. I think we should, because see, 6 years, we have the reasons to persuade. Yes, I think it is only appropriate and befitting for us to take up this issue separately. Take up with Government of India that segregate this aspect in as far as the proposed amendment in respect of the 6th Schedule provision for the state of Meghalaya is concerned, because you have all those other 6th Schedule areas, proposed amendment. It's very, I must say, involving too many stakeholders beyond the stakeholders which is confined to the state of Meghalaya in as far as the 6th Schedule area is concerned. So may I therefore, with this assurance that we put pressure again. I know that this discussion is on. I do not disagree that Honorable Chief Minister or the Deputy Chief Minister in charge may not be taking it up. I know that we must have been taking it up. But I think we'll have to change our strategy, because 6 years is too long a time. Even that timing of introduction of that amendment from 2014 to 19 is 5 years already. Then another 6 years. So therefore, my submission through you, Mr. Speaker, shall be that may we get the categorical assurance from the government to urge upon the Government of India with utmost seriousness, reflecting the kind of crisis that our ADCs are facing in absence of this amendment. I think it is only appropriate that the government should indicate. And another thing is that we can always, I know that sometimes it may be considered as illogical or a precedence, but sometimes, as I have said, when we are confronted with challenges from which we need to come out, we'll have to find a way. How do we resolve that particular issue of enabling the ADCs to pay a salary? I think government can pay some advance and always readjust it subsequently. We have tried earlier. We have paid advance. Even the salaries, even the pension for the MDCs, retired MDCs, we have paid in advance. So now we, as Government of India once told us after that increase of the quantum of the transfer of your share of taxes based on that Finance Commission recommendation, increasing from 32% to 42%. They say that you are flushed with money. So therefore, certain amount of money, I don't think it's a big amount. At least some relief can be done by way of advance, both for Garil's Autonomous District Council and Jaintia's Autonomous District Council. Our honorable member from Ampati, while making this submission, has indicated this one. So with these few requests and submission, in the best interest of our people and to give fruition to our collective intent of coming out of this crisis, I make this submission and would like to just see the response before I express my opinion on the opinion to withdraw or otherwise of the resolution.
Thank you, sir. Sir, yes, once again, I think let me first take up the last point raised by the Honorable LO relating to the salary crisis faced by both this council. One is Jaintia and number two is Garo Hills District Council. Let me be frank with you. Sir, in fact, as of now, even from the share, it is already minus. See, that's why, sir, I think the other day I've already replied. Why ultimately government seen this there's serious consequences if we just leave it like that. Why the Honorable Chief Minister that day said, we are willing to step in, bailing out the crisis. I think this is the issue where we are right now. That day, sir, I've already clarified. I said that don't worry, please don't have any kind of political agenda that we have from the government side, but really we are serious thinking about the welfare, about the livelihood of the employees of these two district councils, which is really very, very unfortunate. So, sir, I will not reply much on this because, as I said to you, we already constituted a committee, be it from the state level as well as to all the three district councils, and now this subcommittee is now on the job. They already even started the meeting with the MDCs, with the stakeholders, even with the employees. And then we have kept that within 45 days, they need to submit a report. We are sincere enough about it, and we are so serious about it. Why we are so serious? Because even CM, he went up to the extent to say that from November, we would like to at least bail out something. So, sir, I will not elaborate much about this since we are waiting for the report from these two committees. So, as far as this issue, again, the amendment, 125th amendment, sir, I could see, though I'm not member of the parliament, but I could see, number one, I could see the seriousness of the government. Because when they introduced in 2019, immediately they refer this proposed amendment of 125th amendment to the standing parliamentary committee. And this standing parliamentary committee, they have already visited all the states. They visited all the states who has this council. And now, in the year 2021, they submitted even the report. Though I don't have the exact date, the exact month, but in 2021, they submitted the report, and now the Home Affairs Ministry is examining, and I'm very sure, because recently when I discussed with the Honorable Chief Minister, when he met the Honorable Home Minister, Chief Minister has already spoken, and sir, not only us who has this problem, be it Mizoram, be it Nagaland, and be it Meghalaya. These are the three district council which is directly affected. So we will not sleep. We will push that this 125th amendment bill is passed in the parliament. And once that is done, I'm very sure this kind of tension that we have, this kind of challenges that we have in all these three district council can be ultimately resolved. So with this few words, once again, sir, I would request once again the Honorable LO to kindly withdraw the resolution.
Yes, please.
Mr. Speaker, sir, again, I would like to thank the Honorable Deputy CM. And with this observation, one observation, I would like to indicate my mind. Now, the issue of being able to create the sense of urgency in Government of India is very crucial for us, because the standing committee, we are all aware, have gone around, and then consultations have been made. 2 years they took, and then 2021 they have submitted. 21, 22, 23, 24, 25, 4 years. That's the reason why we must be able to press upon the Government of India to create that sense of urgency, keeping in mind the situation which we are confronted by. It is very painful when villagers are going and meeting the agitating employees. Some are crying, some are ringing us up. So keeping in that mind, the to create the sense of urgency in as far as the decision to be taken by Government of India is necessary. Therefore, this exercise of the state government to release some advance can be weaponized by the state government to really create that sense of urgency. Look, we have been compelled because of this, because we cannot be just silent spectator. Though the whole burden of responsibility was vested upon Government of India, but since this delay has taken place, therefore we had no other choice but had to give in advance some amount which should be reimbursed by Government of India. I think certain weaponization of this type of decisions can help us also. This is my submission, and it is up to your wisdom to take it or throw it, but I suggest this, and with these few words, I would like to withdraw this resolution, Mr. Speaker.
Thank you.
I take the leave of the House to withdraw this resolution.
Thank you. Since the mover has withdrawn his resolution, now let me put the question before the House. The question is that the honourable mover has leave of the House to withdraw his resolution. Those who are in favour say aye. Those who are in favour, against say no. The ayes have it, the ayes have it, and the resolution has been withdrawn with the leave of the House. Now the House stands adjourned till 10 a.m. on Friday, the 12th September 2025.